Enforceability. In this short video, we will consider the enforceability of contracts, focusing upon a range of circumstances that can make a contract unenforceable. The first such circumstance is a lack of consent, and this is where one of the parties can be said not to have truly consented to entering into the particular contract. An example of a lack of consent is mistake. Now, as a general rule, if a party to the contract has made a mistake, for example, if they have purchased an item of clothing that turns out to be the wrong size, this will not entitle them to terminate the contract or to argue that the contract is unenforceable. The general rule is caveat emptor, which is Latin for buyer beware. A buyer is expected to look after their own interests and be careful to purchase the correct product. If they make a mistake, it's their own fault and their own responsibility. They cannot expect to get out of the contract and get their money back. Having said that, there are certain types of mistake that can make a contract void or unenforceable. So the first type of mistake is called a unilateral mistake. A unilateral mistake is a one-sided mistake, a mistake made by only one of the parties. As a general rule, a unilateral mistake will not make a contract void or unenforceable, but if a party makes a mistake about a fundamental aspect of the contract, and the other party to the contract knows that they have made the mistake and seeks to take advantage of it, that can make the contract void and unenforceable. A second type of mistake that can make a contract unenforceable is common mistake, and this is where both parties to the contract have made the same mistake, and that mistake relates to a fundamental aspect of the contract. Now, usually that fundamental aspect of the contract is something like the very existence of the subject matter of the contract. So if two parties have made a contract where a particular item of property is going to be sold by one party to the other, and it turns out that at the time they made the contract, that particular item of property no longer existed, so perhaps it had been destroyed or it had been stolen, then both parties have made a common mistake, and that particular contract will be void and unenforceable. The third type of mistake that can make a contract void and unenforceable is mutual mistake. And this is where both parties are mistaken, but they've made different mistakes. In fact, what's happening is they haven't really had a meeting of minds. They haven't really reached an agreement. For example, if one party agrees to sell their car to another party, but each party was thinking of a different car that is owned by the seller, then really when they made the agreement, they didn't really agree on the same thing. That's a mutual mistake, and in that case the contract is void or unenforceable. Another example of a lack of consent is duress. Duress arises if one party compels the other party to enter into the contract by threatening negative consequences. So the threat could be to the personal safety of the other party. So for example, sign this contract or I will shoot you. Or the threat can be to the personal safety of the loved ones of the other party. For example, sign this contract or I will shoot your grandmother. The threat can be to the safety of the other party's goods or property. Sign this contract or I will destroy your car. Or the threat can be to the other party's economic or financial well-being. So sign this contract or we will do something that will actually cost you a lot of money because we will be breaching another contract with you or we will commit some kind of tort. Now, a certain amount of pressure in negotiations is fine. You can persuade the other party to sign a contract, but if that pressure goes beyond the point of legality, if you actually threaten to commit an illegal act or to breach a contract or to commit a tort in order to pressure the other party to enter into the contract, then you are in fact engaging in duress, and any contract that results from that will be unenforceable. Undue influence is similar to duress but less explicit. If one party has influence over the other party, for example, a doctor has influence over a patient, or a teacher has influence over a student, or a priest has influence over a member of their congregation, a lawyer has influence over their client, and so on. But if the party who has the influence over the other party takes advantage of that influence, such that the other party is not really exercising their independent judgment, then the contract will be voidable, so able to be voided at the election of the party who's being influenced, on the grounds of undue influence. A similar concept is unconscionability. A contract will be void due to unconscionability if one party has unfairly taken advantage of a special weakness or disadvantage on the part of the other party. Many contracts are made between parties with unequal bargaining power. If the party in the stronger position takes advantage of the other party's weakness or disability, then any contract that results may be unenforceable due to unconscionability. In Commercial Bank of Australia and Amadio from 1983, Mr. and Mrs. Amadio were an elderly couple who spoke little English. They were asked by their son to mortgage their property to the Commercial Bank of Australia as a guarantee for the debts that the son owed. Mr. and Mrs. Amadio agreed, believing that their son's business was successful and that their liability would be limited to $50,000. Unfortunately, Mr. and Mrs. Amadio were wrong on both counts. The bank manager took the mortgage and the guarantee documents to Mr. and Mrs. Amadio to sign. The manager did not explain the documents to Mr. and Mrs. Amadio. He didn't check to see if they understood the risk and the liability they were assuming, and Mr. and Mrs. Amadio signed the documents without reading them. When the son defaulted on the loans, the bank sought to enforce the mortgage and guarantee over the Amadio's property. The Amadios refused to cooperate, and the matter went to court. The court decided that the mortgage and the guarantee provided by Mr. and Mrs. Amadio were unenforceable due to unconscionability on the part of the bank. Mr. and Mrs. Amadio were in a position of special disadvantage because they were ignorant of their son's indebtedness, because of their age, and because of their inability to read and understand English. The bank knew about this disadvantage and should have taken steps to ensure that Mr. and Mrs. Amadio were better informed. The fact that the bank failed to do so meant that they had engaged in unconscionable conduct. In Louth and Diprose from 1992, Diprose was a solicitor and Louth was his client. Diprose was twice divorced and middle-aged, and he had become infatuated with and emotionally dependent upon Louth. Louth claimed that she and her two children were about to be evicted from their home, and she convinced Diprose to give her $60,000 for the purchase of a house. Diprose later sought to recover the gift, and the court had to decide whether or not the circumstances amounted to unconscionability on the part of Louth. The court decided that Louth had behaved unconscionably. Diprose's unrequited love for Louth put him at a special disadvantage, and she had unconscionably exploited Diprose's love for her to benefit herself. Lack of consent is one example of a situation that will make a contract unenforceable. Another one is lack of capacity. A contract will only be enforceable if both of the parties to the contract have the legal capacity to enter into contracts. Now, as a general rule, a person will not have legal capacity to contract if they are a minor, and by minor we mean a person under the age of 18. There are exceptions, and there are certain types of contracts that are enforceable against children, but as a general rule, a contract will not be enforceable against a child. Similarly, a person lacking intellectual capacity will be seen as lacking the legal capacity to enter into contracts. Examples of persons lacking intellectual capacity are people who are clinically insane, people who are intellectually disabled, and people who are obviously intoxicated. It may not be possible to enforce a contract against people in those categories. A contract may be unenforceable because of a lack of legality. A contract can be illegal at common law or illegal under statute. At common law, certain types of contracts are seen as illegal and unenforceable, including contracts to commit a crime or a tort, contracts that promote corruption in public office, contracts intended to evade the payment of tax, and contracts that prevent or delay the administration of justice. So for example, if you and I enter into a contract where I'm going to pay you to assault my neighbor because I'm annoyed with them, that contract will be unenforceable because of a lack of legality. Or if you enter into a contract with a politician where you're going to bribe them in return for them exercising their voting power in Parliament in a particular way, again, that contract will be unenforceable because it's a contract that promotes corruption in public office. And a contract may be illegal because it breaches a statutory prohibition. So there are many pieces of legislation that make certain types of conduct illegal. If a contract is made in contravention of that statutory prohibition, then whether or not the contract itself becomes unenforceable depends upon the precise wording of the statute. So the statute could penalise the conduct of the parties, but it may not necessarily invalidate any agreement that's made. Or it may invalidate the agreement and not penalise the parties. Or it could do both. It could penalise the parties and invalidate any agreement that's been reached in contravention of the statute. A contract may be unenforceable because of a lack of formality. Now, we saw earlier on in earlier videos that most contracts do not need to be in writing. Most contracts do not need to be signed by the parties. There are, however, certain types of contracts that do need to be in writing and signed in order to be enforceable. These include arbitration agreements, checks, consumer credit contracts, real estate contracts, and transfers of shares. If any of these contracts are verbal, if they're not in writing and signed by the parties, then they won't actually be legally enforceable. Now, we've said that most contracts don't need to be in writing and signed, but in reality it's actually good commercial advice to put any business contracts, particularly business contracts involving onerous legal obligations or significant amounts of money, to put them into writing and have the parties sign them. So the advantages of actually reducing a contract to writing and having it signed include the fact that this encourages deliberation and reflection by the parties, the fact that it ensures the availability of reliable evidence about the existence of the contract, it ensures the availability of reliable evidence about the terms of the contract, and it indicates that the agreement was intended to be legally enforceable, which, as you will recall, is the second essential element of a contract.